having me. I think it's really important that people understand the process. As a general matter, states have the power to control their own ballots, and in fact do under the Constitution. And Maine law specifically delegates to me, as Secretary of State, a requirement to review the qualifications for any candidate running for office. So, for example, last week, the Superior Court found that my decision to bar Mr. Chris Christie from Maine's presidential primary ballot due to lack of signatures was lawful and correct. So my job, I qualify Mr. Trump for the ballot, and under Maine law, any registered voter can bring a challenge to that qualification. In this case, there were 3 challenges, and I was required by law to hold a hearing, an administrative hearing, to review the evidence, hear testimony. Both sides were represented by counsel. Mr. Trump was represented by an attorney, and then I'm required to issue a decision. That's my obligation under the oath I swore to the Constitution. My first and foremost obligation is my oath to uphold the Constitution and the rule of law. Now, different states are different. For example, in neighboring New Hampshire, there are more than a dozen candidates on the Democratic presidential ballot, but Mr. Joseph Biden is not on the Democratic presidential primary ballot in New Hampshire, and there are more than a dozen Republican candidates. In Maine, there are 2 candidates on the Democratic presidential primary ballot and less than a dozen Republican presidential candidates. So every state is different. My obligation and duty, my sole consideration, is my oath to uphold the Constitution. So the legislature can always change the laws. I would be surprised if they directed me to stop enforcing qualifications for office. Some have suggested, for example, that I can't enforce age or residency or citizenship qualifications or the 22nd Amendment. I don't think that I'm permitted to put an 18-year-old on the ballot or a non-citizen on the ballot. My job is to look at the qualifications, and if those qualifications are challenged, to make a determination, but there's also a court process. The legislature, if they change that, I will absolutely adhere and follow the law. I reviewed Section 3 of the 14th Amendment very carefully and determined that Section 3 of the 14th Amendment does not say conviction, it says engage. And let's go back and keep in mind that the events of January 6, 2021 were unprecedented and tragic. This was an attack not only on the Capitol and the government officials, the former vice president, members of Congress, but an attack on the rule of law. And the weight of evidence that I reviewed indicated that it was in fact an insurrection, and Mr. Trump engaged in that insurrection under Section 3 of the 14th Amendment. I will always implement what the court decides. And this type of proceeding is not unusual as part of my duties in Maine under Maine election law. In 2022, for example, I held a similar hearing on the qualifications of a district attorney candidate, found him unqualified. That was appealed. The court upheld my ruling. I mentioned Mr. Chris Christie just last week, a Superior Court finding that I had made the right decision in barring him from the ballot under Maine law. But I will always uphold what the court does, and it's part of the job of being Secretary of State. Should the U.S. Supreme Court rule that Mr. Trump be on the ballot, I will in fact place him on the ballot. It's part of why I suspended the effect of my decision until the courts can act. So no ballots are being printed until that Superior Court decision or Supreme Court decision might come down, although we're looking at a very tight time frame.